And the special counsel report on President Trump's handling of classified documents won't be made public. President Trump pleaded not guilty to 37 criminal counts after prosecutors said he repeatedly refused to turn over classified documents taken to Mar-a-Lago after he left office. Judge Aileen Cannon dismissed the case after deciding Smith's appointment was unlawful. Now she's barring the release of the report, saying, quote, it would cause irreparable damage to former defendants and, quote, contravene basic notions of fairness and justice. Chief Investigative Correspondent Aaron Katursky is here for more on that. So, Aaron, what went into this decision and how significant is this?
Well, it's significant because we're not going to see what Special Counsel Jack Smith prepared, what he actually found. And as you say, President Trump pleaded not guilty, denied mishandling classified documents. But we know classified documents were found since from our reporting, but won't know the full extent because Judge Cannon has decided the report cannot be made public. And this was something that Trump asked for, his Justice Department agreed with, and now the judge that he appointed has affirmed.
Is this the end of the discussion, or could these documents still be released eventually?
It's not clear who necessarily would appeal because everyone agrees, right? It's Trump, the people he appointed, but it's possible members of the news media could try to force the issue at the 11th Circuit or even higher if it comes to that. But for the moment, the report is not going to be made public ever. The judge did not go as far as Trump wanted, which is to say destroy the report. It will continue to exist, but it's going to be limited disclosure to within the Justice Department.
A quiet Tuesday afternoon in a federal courthouse in Florida. Rows of wooden benches, fluorescent lights buzzing overhead, the smell of old carpet and legal tension hanging in the air. Dozens of journalists crammed into press seats, their notebooks ready, their instincts telling them something important is about to happen. And then the judge speaks. 3 words that would change everything. Unseal those files. In that single moment, months of strategy, millions of dollars in legal fees, and an elaborate architecture of secrecy built by one of the most powerful defense teams in the country collapsed like a house of cards caught in a hurricane. Within 24 hours, over 8 million people had watched the footage of what happened next. It trended on every platform imaginable. It dominated every news broadcast, every podcast, every dinner table conversation from coast to coast. But to understand why that courtroom erupted, why lawyers started screaming at a federal judge, why papers went flying, why one of the most closely watched legal cases in modern American history suddenly detonated in spectacular fashion, you have to go back to the beginning. Because this story didn't start in that courthouse. It started in January of 2021. And it started with boxes. Every president who leaves the White House goes through the same process. It's structured, methodical, and not optional. There are movers, there are archivists, there are federal agents coordinating the transfer of official materials, documents generated during a presidency, every memo, every briefing, every piece of correspondence that touched the hands of the executive branch, all of it belongs to the government. All of it is supposed to go under federal law directly to the National Archives. This is not a suggestion. It is not a tradition. It is the law of the United States of America. And for every president who came before, the process worked. Materials were cataloged. Records were preserved. The machinery of history did its job. But then came January 2021, and something different happened. Instead of routing those materials through proper channels, instead of allowing the archivists to do what archivists are legally required to do, boxes were diverted. Dozens of them, packed up and sent south to a private club on the Florida coastline, a place called Mar-a-Lago. Now here's where it gets serious, and I mean genuinely, legally, historically serious. Because these weren't boxes of old campaign memorabilia or personal family photographs. These were official government documents, and among them classified materials, intelligence reports, briefings on foreign governments, details about military capabilities, information about national security matters so sensitive that under normal circumstances, they would only ever be viewed inside secured facilities by personnel with the highest clearance levels, using protocols designed to prevent exactly the kind of exposure that was now quietly happening inside a luxury resort bathroom. Yes, a bathroom. because when federal investigators eventually arrived to examine what had been taken, some of the most sensitive classified documents in American government were found stacked in cardboard boxes sitting in a storage room adjacent to a shower. Let that image land for a moment. Documents that outline nuclear capabilities, intelligence gathering methods, and the identities of sensitive intelligence sources, piled up like old magazines. In a building where guests wandered through on a daily basis, where staff moved in and out, where the security apparatus bore no resemblance whatsoever to the kind of environment that classified materials are legally required to inhabit. The government knew something was wrong almost immediately. The National Archives, doing exactly what it exists to do, noticed that certain materials were missing from the transfer. Official records that should have been handed over were unaccounted for. So the archives reached out to ask for them back. The response initially seemed cooperative enough. Sure, some materials were returned. A handful of boxes made their way back through official channels. Problem solved, right? Wrong. Because after reviewing what had been returned, the archives realized the picture was incomplete. Classified materials were still missing. The response to follow-up requests grew more complicated. Months passed. The pressure increased. What had begun as an administrative inquiry was gradually transformed through resistance, delays, and incomplete cooperation into something far more serious. The Justice Department opened an investigation, and when a Justice Department investigation concludes that the evidence justifies court-authorized action, the next step is not a strongly worded letter. The next step is federal agents, a warrant, and a search of the premises. In the summer of 2022, that search happened. Federal investigators descended on the Florida property. They searched, they cataloged, and what they found confirmed what the archives had suspected. Classified documents, significant quantities of them, including some bearing the highest classification markings in the United States government, had been sitting at a private club for months. Some were labeled top secret. Some contained compartmented intelligence. Some detailed information about nuclear programs. Some outlined surveillance methods so sensitive that exposure could genuinely endanger lives and compromise national security in ways that couldn't be undone. The reaction to the search was instant and furious. Claims of political persecution filled the airwaves. The word witch hunt was deployed with maximum velocity. The entire operation was characterized as an unprecedented abuse of power orchestrated by political enemies. But the documents were real. The classification markings were real. The fact that this material had been sitting outside a government-secured facility for the better part of a year, that was also very, very real. Out of that investigation came charges, serious ones. The formal legal question was essentially this: did someone illegally retain classified national defense information after leaving office? Did that person obstruct justice by refusing to return materials that the government, through multiple official channels over an extended period of time, had specifically requested back? And did that person on multiple occasions display classified documents to individuals who had absolutely no security clearance and no legal authorization to view them? These weren't technical procedural questions. These were criminal charges. 37 counts in total. A not guilty plea was entered. Denials were issued, and the legal machinery began its slow, grinding march toward a trial that everyone knew was going to be unlike anything the American justice system had ever seen. A sitting or recent former president facing federal criminal prosecution in a case built around some of the most sensitive classified materials in government. The defense team assembled, and from day one their strategy was clear: control the information, keep the evidence sealed, manage what the public could see. Because as long as the documentary record stayed locked away, as long as the testimony remained confidential, they could characterize the prosecution's case however they wanted. They could frame the narrative. They could dismiss the charges as baseless without anyone being able to scrutinize what the evidence actually showed. For a surprisingly long stretch, that strategy worked. Documents stayed sealed. Testimony remained confidential. The full picture of what investigators had built witness by witness, document by document, through months of painstaking investigation stayed frustratingly out of reach for the press, the public, and the broader jury pool that would eventually decide this case. But then something shifted. The prosecution made a calculated move. They filed a motion arguing that continued secrecy no longer served any legitimate purpose. Their position was direct. The public has a right to understand what evidence exists in a criminal case of this magnitude. These materials do not need to remain sealed for national security reasons. The only purpose served by keeping them hidden is shielding one defendant from accountability. Open the files. Let the country see. The judge reviewed the arguments from both sides, weighed the legal standards, considered the competing interests, and then the ruling came down: unseal the documents, make them public. Inside that courtroom, the moment the order was announced, something broke. Because what was contained in those files, what the defense team knew was contained in those files, wasn't just inconvenient, it was catastrophic. And in the instant that judicial order became reality, every calculation the defense had made, every motion they had filed, every strategy they had constructed around the assumption that these secrets could be preserved, all of it evaporated. What happened next spread across the internet within hours. 8 million views in under 24 hours. Trending on every major platform. Legal analysts watching in stunned silence. Regular people forwarding the clip to friends with a single line of text. Did you see this? A defense attorney, one of the primary architects of the legal strategy that had been carefully maintained for months, rose to address the court. And what began as a legal argument rapidly, visibly, publicly disintegrated. The volume climbed, the tone sharpened. Within moments, the room had shifted from a legal proceeding into something closer to a scene of controlled chaos. Accusations of ambush tactics, claims that the entire proceeding had become fundamentally unfair. Objections that escalated past coherence and into something rawer, less professional, more desperate. Other members of the legal team scrambled. There were urgent whispered conversations, someone tugging at a sleeve, the unmistakable body language of a team trying to contain a situation that had already escaped containment. And the judge was not having any of it. The gavel came down, hard, multiple times. People in the room later said they could feel it reverberate through the floor. The demand for order cut through the chaos like a blade, sharp, unambiguous, final. But the damage was done, and it had been witnessed by everyone in that room, recorded by everyone with a device, and broadcast to everyone with an internet connection. Now here's why that moment matters beyond the spectacle. Because courtroom eruptions happen. Lawyers lose their composure. Tempers flare under pressure. These things on their own can be explained away. What cannot be explained away is what those unsealed files actually contain. Grand jury transcripts, sworn testimony delivered behind closed doors by people who were physically present at Mar-a-Lago during the period when these decisions were being made. People who had every reason to protect the subject of this investigation. People who were loyal, who had been trusted, who were part of the inner circle. People who, under oath and under penalty of perjury, told the truth about what they witnessed. And their testimony was not friendly. Witnesses described watching the defendant personally sort through boxes of classified materials. They testified about conversations in which specific documents were discussed, and a decision was made to keep them not because of confusion about what was allowed, not because of administrative error, but because he simply wanted to retain them. They testified about instances in which classified files were removed from secure storage and shown to visitors at the private club, visitors who had no security clearance, no official authorization, no legal basis whatsoever for viewing materials of that classification level. Every detail that the defense team had worked so desperately to keep buried, every piece of testimony that had been locked away behind sealed court records was now public, available for download, for analysis, for broadcast, for every journalist, legal analyst, and member of the eventual jury pool to examine at their leisure. But there was one more layer to this, and it may be the most extraordinary element of the entire case. Some of that testimony came from attorneys who had previously represented the defendant. Attorney-client privilege is one of the most fundamental protections in American law. When you speak privately with your lawyer, those conversations are protected. They cannot be compelled in court. They cannot be used against you. The relationship between attorney and client is legally sacred precisely because the justice system depends on defendants being able to speak honestly with their legal counsel. But there is an exception, and it's a significant one. It's called the crime-fraud exception, and it applies when a court determines that a client may have been using their attorney's advice not for legitimate legal purposes, but to further or conceal criminal activity. In that circumstance, the privilege shield shatters. The attorney can be compelled to testify. The conversations come out. For a judge to invoke the crime-fraud exception isn't something that happens casually or lightly. A federal judge has to review the evidence and conclude that there is sufficient basis to believe that criminal activity was occurring and that legal counsel was being used as part of that activity. Federal judges don't make those determinations without serious, substantiated reason. And in this case, that determination was made. Former legal counsel testified, described conversations, laid out details about what was known, when it was known, and what was decided in response to that knowledge. Now combine that with the first-hand eyewitness testimony from inner circle associates, and now combine that with the physical evidence, the actual classified documents recovered by federal investigators. What you have is not a political allegation. What you have is not a partisan attack dressed up in legal language. What you have is a criminal case with multiple corroborating pillars, each one reinforcing the others, each one making the defense's core narrative innocent misunderstanding, administrative mix-up, politically motivated persecution harder and harder to sustain. Let's be honest about what the defense was actually arguing. Their core position relied on a characterization of innocent confusion. Yes, documents were taken. Yes, they ended up at a private residence in Florida. But there was no criminal intent. There was no deliberate effort to obstruct. It was a misunderstanding complicated, perhaps, by the chaos of a presidential transition, but fundamentally innocent in nature. That narrative required the public not to know certain things. It required the testimony of eyewitnesses to stay sealed. It required the grand jury transcripts to remain confidential. It required the conversations with former counsel to stay protected behind attorney-client privilege. Once those protections fell, once the judge ordered transparency, the entire defensive framework had to confront a new reality. You cannot claim innocent confusion when eyewitnesses testify under oath that they watched the defendant personally sort through the boxes and choose what to keep. You cannot claim administrative misunderstanding when testimony establishes that specific requests to return the materials were received, understood, and refused. You cannot claim cooperation when the documented record shows that materials were moved, concealed, and not disclosed to investigators repeatedly over an extended period of time. And you cannot dismiss the courtroom reaction as merely a bad day under pressure, because what that reaction communicated to everyone watching in real time was the unmistakable visual of a team that had just watched their strategy collapse. Innocent people's lawyers don't scream at judges. They don't scramble. They don't look panicked. An innocent client's defense team welcomes scrutiny. They want the evidence examined. They want the testimony heard, because they know it will vindicate their client. That is not what the world watched in that courtroom. Here's where the story takes another extraordinary turn, because this case ultimately didn't reach a jury. The judge presiding over the case made a ruling that sent shockwaves in a different direction entirely. After months of legal maneuvering, the judge dismissed the case altogether, concluding that the special counsel who brought the charges had been improperly appointed, not on the merits of the evidence, not because the documents weren't real, not because the witnesses weren't credible, but on a procedural legal question about authority. And then in a decision that compounded the controversy, the same judge blocked the special counsel's final report from being released to the public. The argument: releasing the report would cause irreparable harm to the former defendants. It would violate fundamental principles of fairness. The public, the judge concluded, had no right to see what investigators had actually found. The report will not be destroyed. It will remain within the Department of Justice, but it will not be made public. Think about what that means. The investigation is over. The charges are gone. And the full documented account of what federal investigators concluded, what witnesses said, what evidence was gathered, what the classified documents actually were, will not see the light of day. at least not yet. News organizations are reportedly exploring legal avenues to challenge that ruling. Appeals courts may be asked to weigh in. The story of these documents in that sense is not fully closed, but for now, the public will not know the complete picture. Let's step back from the specific facts of this case and look at the larger stakes. Because this isn't just a story about one man and one set of classified documents. This is a story about the architecture of American democracy, and the questions it raises don't have simple answers. What are the limits of presidential power when it comes to classified information? The law is clear that presidents cannot simply take classified materials and retain them indefinitely after leaving office. But what happens when someone in that position believes their own authority supersedes that legal clarity? What happens when the machinery of accountability tries to engage and is met with resistance at every turn? How does the justice system handle a defendant who is also a political figure commanding enormous public loyalty? How do you conduct a fair trial when half the country sees the prosecution as legitimate law enforcement and the other half sees it as coordinated persecution? How do you impanel an impartial jury in a case that has been saturating the national conversation for years? What happens to classified national security information when it leaves secured facilities and enters unsecured spaces? What are the real-world intelligence consequences? Are there foreign governments that now know more than they should because of what ended up in those boxes? These questions may never be fully answered publicly because answering them would require disclosing the very information whose exposure is the problem. And perhaps most fundamentally, what precedent does this set? Future presidents are watching this case. Future administrations are taking notes. The outcome, both legal and political, will shape how the people who come after understand their obligations, their limits, and the consequences they can expect if they test those limits. Somewhere beneath all the legal analysis and political combat, there is something deeply human happening. People who worked for someone who were loyal to him, who believed in him, who stood beside him through years of political battle, found themselves in a federal grand jury room, under oath, legally compelled to describe what they witnessed. That is not an easy position to be in. The pressure is immense. The personal cost is real. Friendships end. Careers shift. Lives are permanently altered by the choice to tell the truth under oath about what you saw and heard. And on the other side, defense attorneys who took on a case with an almost impossible assignment defend a client against evidence that includes testimony from his own inner circle, physical classified documents recovered by federal agents, and grand jury transcripts that describe in specific detail deliberate decisions made about those materials. There are no heroes in a story like this. There are no clean narratives. There is only the messy, complicated, painfully human reality of a legal system trying to apply consistent standards to an inherently inconsistent situation, a case unlike any other in the history of the Republic. The case may be dismissed. The report may be sealed, but the story is not finished. Legal challenges to the report's suppression are likely. Media organizations have a long tradition of fighting for public access to government records, and this case, given its unprecedented nature, is likely to produce continued legal battles over transparency. The broader questions raised by this investigation won't go away. They've been injected into the bloodstream of American political discourse, and they'll circulate there for years in future elections, in policy debates about presidential records, in constitutional arguments about executive power and accountability. The documents that were found at Mar-a-Lago are real. The classification markings on those documents are real. The testimony from the people who were present when decisions were made about those documents, that testimony is real, and it exists in sealed form within the Justice Department, even if the public can't read it today. History has a way of surfacing things that power tries to bury. Archives are eventually unsealed. Witnesses eventually write memoirs. Investigators eventually publish their accounts. The full story of what happened, what was in those boxes, what was decided, and what it cost will emerge. Perhaps not today. Perhaps not in a form that satisfies everyone's demand for clarity and accountability, but it will emerge. Here is what we know with certainty. Classified documents were taken from the White House when a president left office. They ended up at a private club in Florida, stored in ways that violated every protocol designed to protect sensitive national security information. The government asked for them back. The requests were refused. Federal investigators searched the premises and found what they were looking for. Criminal charges were filed. A legal battle of extraordinary complexity and political charge unfolded. And then through a combination of a controversial judicial ruling and an equally controversial suppression of the investigative report, the full picture was kept from the public. A courtroom erupted. A defense strategy collapsed in real time, in full public view, captured on video and distributed instantly to millions of people. Grand jury testimony from the defendant's own associates entered the public record, if only briefly before the door was closed again. And now, the country sits with an incomplete picture, a dismissed case, a sealed report, questions that remain officially unanswered. But perhaps the most important thing to hold on to in this story, and in every story like it is this: the truth doesn't care whether it's convenient. The evidence doesn't disappear because a case is dismissed. The testimony doesn't unhappen because a report is sealed. The files existed. The witnesses spoke. The documents were real. And somewhere in the archives, in the sealed records, in the memories of everyone who was present in that courtroom, the full story still waits. Strap in, because this chapter may be over, but the book is still being written.